Hey, how are everybody doing today? This is your host, Chuck Cook, here at the Immigration Hour podcast and our own live here on Facebook and YouTube and LinkedIn and Twitter. Wanted to talk today real briefly, because I'm late, because I had to go to the doctor. It happens sometimes. I want to have two Supreme Court cases. These two Supreme Court cases that have come down in the last couple of weeks literally make things so much harder on immigrants. Let's talk about the first case that came down. This is a case called Campos-Chavez. Campos-Chavez is a case out of the Fifth Circuit. Actually, it's a case out of several different circuits. It was actually a kind of a split issue. The issue is this. Several years ago, the Supreme Court in a case says that under the Immigration Nationality Act, when somebody is put into deportation proceedings and they are given to what's called a charging document, called a notice to appear, it must include all of the information. And if it doesn't include all the information, it's not valid. No, that makes sense, right? I mean, and typically what immigration would leave out is when and where your hearing was. Kind of important information. The government's argument was, well, we send a subsequent document with that information, which they may or may not get. They have to sign for the notice to appear, but they don't have to sign for the hearing notice. Obviously, two different things, and they're both vitally important. But they didn't sign for it. They said, the Supreme Court said, no, you can't do that. So a couple years later, another Supreme Court case, they said, because government was trying to ram this down their throats, saying, yes, two count. And the court said, no, two don't count. You got to do it in one. Well, this case, Campos-Chavez, then comes on a couple years later. Campos-Chavez is different because Campos-Chavez is about people who had been ordered deported that were moving to reopen their case. And in two circuits, they said, yes, you can reopen the case because you didn't get notice. You didn't get two separate notices. They didn't comply with the law. And in the Fifth Circuit said, no, you're fine. You can count both notices. Supreme Court just came down 6-3. Alito, Mr. Lover of immigrants himself, a man who has not yet met an immigrant that he won't rule against, issued a decision that said, no, obviously the government's really busy. They're really busy. They got lots of things going on. You can't expect the government to tell you when and where your deportation hearing is when they tell you they want to deport you. No, they can tell you later. They can send you a letter later if they want to. Hopefully it goes to the same address. Doesn't really matter. Boom, just like that. An avenue which we were using to help literally hundreds of thousands of immigrants who had benefited from the first two decisions now cut off. Now, still, the government still has to issue notices with the date and time. And I think, arguably, this is about old motions to reopen old deportations. But still, really? Gosh, Justice Alito, don't be such a hater, man. Don't be such a hater. That's Campos-Chavez. And there are 1 million people with deportation orders that now are going to have a much harder time reopening their cases. That's what Campos-Chavez is. The next case that came out just this last week is a case called Munoz. Now, interestingly enough, I spoke at the annual conference of the American Immigration Lawyers Association 2 weeks ago on Munoz with the young lawyer who argued Munoz at the Supreme Court. And they had not yet issued a decision. Then Munoz is about a rather obscure thing called consular non-reviewability. Or in other words, who has a right to sue a consulate when they make a bad decision? Now, one thing we know from prior precedents is that the foreign national who is denied a visa has no appellate rights of an appeal of that decision. Now, arguably, you can if there's a legal error that caused that decision to be made, there's obviously legal recourse. You can go to court on what's called the declaratory judgment action, a legal error by a consulate. But a factual information applied to the law, you can't get around that. This case was somewhat different. It was kind of like that, but somewhat different. Now you can also, by the way, still sue consulates who don't make a decision. I mean, so you can still sue them. They're taking 3 years, your administrative processing, 2 years, a year. You can sue them on that. But Munoz said, in this case, was a woman whose husband went to the consulate in El Salvador to get a green card. She had filed for his waiver. The waiver had been approved, which means he supposedly has no other grounds of inadmissibility. And he goes to the consulate and says, we deny you because we think you're MS-13. But they don't tell him They don't tell them why. Well, first of all, they don't even tell them that. They just said you're denied, and they cite a rather obscure statute. A rather obscure statute about other reasons to deny you for crimes, but they have to tell you. So she ended up suing. This case has been going on for like 9 years, and it's a permanent bar, by the way. It's a lifetime bar. You can't ever get around this. Ironically, if he'd have stayed in the country, the new Biden program would have allowed him to get a green card. Yeah, that's how crazy this is. So this lawsuit is filed, and the court initially says no, you can't sue the government. And then it gets remanded by the Ninth Circuit. Ninth Circuit says no, the wife who has a liberty interest in her husband and living with her husband in the United States can sue. And so as part of that, the government disclosed that he had tattoos that they thought were gang related. And her lawyer got an expert in gang tattoos. And no, those are not gang tattoos. Those are just tattoos. You know, this is why we hardly ever send anybody to a consulate with a tattoo, by the way. But then the government appealed the case. So she actually won. She got her information. But the government, rather than just saying, you know what, we'll let him in, he's not really, you're right, they appealed. They appealed that case. And that's all the way to Supreme Court. Supreme Court took the case, and they ruled this key thing, that there is no legal right for a U.S. citizen to live inside the United States with their spouse. And as a result, because she could not show an intentional act by the consulate in making this decision as contrary to law, which of course she can't do without interviewing the consulate officer, looking at the documents, which she can't get, there is no case. So I have a similar case. A young man, a 17-year-old, sent out by his stepdad who had adopted him, done all the paperwork. He went down for his interview, and they said he had no tattoos. They just said, we think you're in a gang. He was 17 years old. There's no evidence. There's nothing. And he was never in a gang. You can't sue over that anymore. Now, the last case that I'm going to briefly talk about, of course, is our DV lottery case, the Go Gomez case. Let me just pull up a little link here. The Go and our Gomez Acer case. So yesterday, when myself and Greg were out of town, we couldn't go live then. And we're going to go live today at 3 o'clock. 3 o'clock today, Aaron and I will be online. Hopefully Greg will join us. I don't know if Jesse will be able to join us or not. And we're going to talk about the decision. But this decision basically by the Court of Appeals is kind of the same thing as Munoz and Campos, basically saying, yeah, you don't really have a right to sue. No, the court can't order any relief for you. So we're going to go into detail at 3 o'clock on the decision and where we may or may not go from there. But I want to do a quick live today to go over these things. We got a couple comments here. I'll go into them. I got to be done by 2, so that's why I'll come back a little bit later. Licha Manicha wants my Manny. I don't know what that means. Curtis, I'm not Curtis. Curtis is a great lawyer. He did his live yesterday. We strongly believed it was not lost the battle. We are winning. Well, here's what really ticked me off about that decision. It's a short decision. It's not particularly that well written. It's just we don't think the judge did what he could. It took them 21 months to make that decision. Most judges would have written that in a week. If that was their position all along, why 21 months? It's really frustrating. Henny, in Go, I understand why it took 2 years. Yeah, I just talked about that. I see hope when I see your face. Well, thank you, Noble. Shimmer, do you know laws for I ended up filing for a law, 4 months prior I got his green card, is not denied. Someone did not do much journalistic find a law. Shimmer, I do not understand that question. You should call. You should call and make an appointment so we can go over your case. Remember, if you want to talk to me, call that appointment. Do Zoom wherever in the world. We can Zoom. We can call. Whatever you want to do. So that's it for right now. We're going to come back at 3 o'clock with Aaron. And hopefully Greg is actually in Turkey today. He's going to join us in the evening in Turkey. And we're going to go over the decision for about a half an hour or so. So join us at 3 o'clock today on our Impact channel. I'll also be here on our Twitter channel. And so it'll be on our Facebook page. It'll also be on Twitter. And of course, it'll be on. I'll probably put it on LinkedIn as well. So we'll see you here at 3 o'clock to talk about those other decisions. Till next week, when I do it in Spanish, we'll talk more about immigration then. Have a great week. Bye-bye.